Good morning. This is an open hearing of independent inquiry into matters relating to Afghanistan. Please can I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the Chair of the inquiry, the Right Honourable Sir Charles Haddon-Cave, has made a restriction order dated 1st of May 2024 in relation to the conduct of those who are attending the hearing. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The first part of the order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the Chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the Chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. The second part of the order, which applies to the hearing scheduled to take place today, the 3rd of May 2024, arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. Where those who have supplied evidence to the inquiry have applied to restrict information from publication outside of the inquiry, in some instances the Chair has made restriction orders, the effect of which is to protect that information. A restriction order prohibits the use, publication, or dissemination of the information that it covers. In the event that something is said during the course of this hearing, which may breach a restriction order made by the Chair, the evidence may be halted and the hearing room and annex may be cleared for closed legal submissions as to whether any restriction order has been breached, and the live stream YouTube recording will be temporarily stopped for this period. Counsel to the inquiry or the solicitor to the inquiry must be informed of any request to make an application for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the Chair has finally determined the application. Every restriction order is subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of that order. Court rise.
Before turning to deal with the business of today, I'd like to give a brief update about the work of the inquiry these past few months. I can tell you that the inquiry has been making good and rapid progress. Since the open hearings in February, the inquiry has held a large number of closed hearings. As I previously ruled, and you'll find all my rulings on the inquiry website, it is necessary to hold many hearings in closed for reasons of national security, the security of the witnesses, and achieving best evidence. The inquiry heard the first part of what has become known as complaints and concerns, and received evidence from UKSF witnesses who told the inquiry of their individual and shared concerns as to the activities of UKSF-1 when conducting deliberate detention operations in Afghanistan during the period mid-2010 to mid-2013. To be clear, those concerns included the belief that A, UKSF-1 had taken the law into their own hands, B, that UKSF-1 had committed multiple murders, and C, that UKSF-1's conduct had been deliberately covered up. Further aspects of the complaints and concerns will be heard in due course. The inquiry then commenced the DDO evidential hearings. Prior to doing so, I and members of the inquiry team attended a detailed practical demonstration of the military tactics, techniques, and procedures used in a DDO. The inquiry has published on the website, at my direction, the inquiry's DDO investigative strategy, which explains the 3 rolling phases of the inquiry's investigation into the DDOs. This sets out in some detail the carefully structured approach that the inquiry is taking to its investigation into DDOs, the extent that the inquiry is able to do so in open, and the very considerable amount of work involved in this crucial aspect of the inquiry. I'm pleased to be able to say that the inquiry has now completed hearings in phases 1 and 2 of the 3 phases of the DDO investigative strategy. Phase 1 of the DDO evidential strategy began with an overview analysis of the conduct of hundreds of operations carried out by UKSF, which are the subject of the terms of reference. From the initial documentary material that has so far been disclosed by the MOD, the inquiry team prepared a separate summary document for each and every one of the DDOs in scope, which identified the key actions and results of that DDO. Example summaries have been published on the website. And then, during days of evidential hearings before me, the inquiry considered not only what had occurred, but also what had been found during any search of individuals or of the compounds where the operations took place, as well as whether anyone, and if so who, had been detained or killed during those operations. The inquiry then moves straight on to phase 2 of the DDO evidential strategy. This involved subjecting a selection of approximately 20% of the total phase 1 DDOs to a more detailed and rigorous analysis. That selection was chosen in order to cover all aspects of the operations and to reflect the complaints and concerns that had been raised either at the time or since. Having identified the selection from all the DDOs in scope, the inquiry sought disclosure of the relevant military paperwork relating to what took place on target and what was done afterwards to review both the actions and the outcomes. The paperwork that was provided in the phase 2 disclosure exercise by the MOD, comprising many lever arch files, was then carefully analysed by the inquiry team, and a separate dossier for each of the DDOs selected was prepared. Over the course of the many long days of closed evidential hearings, that material was then critically examined, and every aspect that gave cause for concern or had the potential to do so was raised, identified, and recorded. The result of these intensive tranches of work by the inquiry team in phases 1 and 2 is that the inquiry now has a clear evidential picture of all the DDOs that were conducted by UKSF over the 3-year period, mid-2010 to mid-2013. And significantly, the inquiry is now in a position to identify those particular DDOs in respect of which there are important unanswered questions and/or unexplained events. There remains phase 3 of the DDO investigative strategy. This has so far involved selecting a further sample of DDOs and seeking disclosure of all relevant material held by the Ministry of Defence in respect of them, and will in due course involve witness statements being obtained from particular service personnel and subsequent evidential hearings involving those witnesses. Let me now turn to the business of today. I had to call this hearing this morning first because of growing concerns about the repeated failures by the Ministry of Defence to meet the deadlines for responding to the inquiry's Rule 9 requests. Over the past 12 months, the relevant deadlines have been met in only approximately 20% of cases. Matters have come to a head recently because of a letter received from the Government Legal Department on the 17th of April, revealing that the MOD now expect at least 6 months' delay in disclosing the documents required for DDO Phase 3. The Secretary to the Inquiry, Piers Doggett, responded to GLD on the 25th of April on my behalf, stating that this was quite unacceptable and seeking an explanation as to why this has come about and what immediate steps were being taken to rectify the situation. The correspondence is now on the website. As the inquiry letter explained, the problem appeared to be long-standing failure by the MOD to resource their inquiry response teams sufficiently, and more recently, a failure in the last few months to gear up in preparation for Stage 3. This is despite knowing for months that this major tranche of work was coming down the pipeline. And I note that similar problems seem to have been encountered by Mr. Justice Swift during the judicial review proceedings. I do not wish to detract in any way from the hard work that I know members of the existing MOD legal team and the MOD disclosure team have done over the past many months to assist the inquiry, and the very good working relationship that has been formed with the inquiry team. And I pay tribute to the efforts that they have made, the fruits of which are evident, as I've said, in relation to DDO phases 1 and 2. However, the fact that the existing MOD teams were struggling to cope with the volume of work and the pace of the inquiry has unfortunately been evident for a long time. The revelation that the MOD now expect to have to delay the DDO Phase 3 timetable by at least 6 months is, of course, extremely troubling. Getting to the bottom of these grave allegations should not be prolonged any more than is absolutely necessary. For the sake of the reputation of the country's special forces and the armed forces more generally, and for the sake of all those affected, the other core participants, and in particular, the Afghan families. I would remind everyone of my terms of reference set by the Secretary of State for Defence. Paragraph 8. The inquiry should be undertaken with sufficient pace to enable findings to be made and resulting recommendations to be actioned as soon as possible. The inquiry will use its best endeavours to report, at least on an interim basis, within 12 to 18 months. The inquiry should report to the Secretary of State for Defence, who should publish the report to Parliament. 9. The Secretary of State is expecting maximum cooperation from MOD personnel. The inquiry will have full access to all documents and evidence in whatever form and witnesses, including former and current service personnel and officials. This was reinforced by a strong message sent out last year by the Chief of the Defence Staff, Admiral Sir Tony Radakin, and the Permanent Under-Secretary, David Williams. They said that proactive cooperation was expected from everyone to support the inquiry. This morning's hearing, I think, will be shorter than it might otherwise have been because of a detailed letter received yesterday from Elizabeth Mackey of the GLD on behalf of the MOD, for which I am grateful. The team are still studying the letter at the moment, but I expect that Mr. Connor, you will wish to explain shortly what is contained in the letter and the MOD's plans to rectify the current situation so far as is now possible. It is now, I fear, inevitable that the inquiry's DDO timetable will have to be put back. The only question is how far, and what rapid practical steps can now be taken to mitigate the current unfortunate position. The inquiry team are already working to see what adjustments can be made to other work streams to take account of the current position. Before I turn to Mr. O'Connor, Mr. Greenie, would you like to say anything?
So thank you very much for the opportunity to make submissions, but in fact we have none to make.
Thank you. Mr. Hermer.
Occupy you with 2 minutes of observations, if I may. You've alluded to Ms. Mackey's letter that sets out in some detail the steps that have been taken and will be taken by the MOD to seek either to comply with your orders or to set out why they have been unable to do so to date. One point that shines through of concern from Ms. Mackey's letter is that it appears from its contents that it has come somewhat as a surprise to the Ministry of Defence, it is said, that the work that they are required to do is so extensive. We say so that is a very surprising position to adopt. It is surprising in light of the judicial review proceedings that commenced many years ago, from which it would be clear what the ambit of the inquiry that was sought would be. If that was not clear enough, it was made clear beyond peradventure by the terms of reference that you set. And so it is difficult to understand why it is only now that the penny is said to have dropped in the MOD about the requirements for personnel to comply with orders from you. And the failures are not ones that fall to be assessed in a vacuum. Because as we have set out, sir, in a note to you and copied to the other interested parties, the concerns that you have raised mirror those concerns expressed by Mr. Justice Swift in the judicial review proceedings, in which, in the most trenchant terms, he criticised the MOD for their disclosure failures and what was a cavalier attitude to compliance with orders of the court. Now, sir, you have touched upon the importance of your inquiry proceeding at pace. Can I just identify 3 aspects of that? Firstly, to those that I represent, that you can identify whether there are credible allegations of criminal conduct, including murder and cover-up. Because if those allegations are shown to be well-founded, then it will be imperative that prosecuting authorities are able to look at this matter and, where appropriate, to prosecute, either at lower ranks for murder or at the highest ranks, both in military and potentially outside the military, for charges related to a cover-up. The longer matters take, the more difficult the task will be for prosecutors. And that's a grave concern for the families. The second concern is the flip side of that. These are allegations that will hang over service personnel. If they are shown to be unfounded, that there are no credible basis, then the sooner that that is established, the better for those to whom the Ministry of Defence owes a duty of care. And thirdly, there is the overwhelming public interest in matters moving at pace. It is hard to think of more serious allegations against the armed forces. Lessons, if these allegations are shown to be credible, there will no doubt be profound lessons and changes that will need to be given effect to. And the sooner that takes place, the better in the public interest. So those underline, sir, our grave concerns at another pattern emerging of the MOD failing to provide disclosure as required. So before I sit down, can I raise one further matter of concern arising out of Ms Mackey's letter? And it's a point that I will just identify this morning, and then we will develop in correspondence. And that is the suggestion in the letter that those within the chain of command, including those within the chain of command in special forces, are involved in the review of disclosure. And we would have grave concerns if the disclosure process was not free from chain of command obligations and was not carried out by those who would be thoroughly independent of it. I raised that because it jumped out to us from Miss Mackey's letter, and it's a matter we will elaborate upon in correspondence, but I thought it appropriate to raise it this morning as well. So those are my observations.
Thank you, Mr. Hammer. Mr. O'Connor.
You have, as you've already indicated, read our letter of yesterday's date, and indeed, as you've said, it is now available for anyone to see on the inquiry website. It is a lengthy letter, and I hope it provides the type of detail that was understandably sought in Mr. Doggett's letter to the MOD of the 25th of April. So I will, of course, come to address the matters raised in the letter, in particular those that you have highlighted this morning. But I wish to start by renewing the apology to you and to all those involved in this inquiry that is contained in the letter. This inquiry was established by the Secretary of State in order to address allegations of misconduct by UK Special Forces that are of the utmost gravity and concern. I can assure you, sir, that those at the highest level of the Ministry of Defence, ministers, the heads of services and senior officials, all share your desire that this inquiry is conducted thoroughly, fairly and at pace. Against that context, it is a matter of considerable regret that we are here today explaining why we have failed to meet deadlines that you have set, and in particular one deadline that will have knock-on consequences for your intended schedule of hearings. We apologise to you and to all others involved in this inquiry that we have fallen short. We've explained how and why this has occurred in our letter, and I will touch on some of those points in a moment. We hope you will accept, sir, that what has happened does not reflect any lessening of the MOD's wholehearted commitment to supporting you and your team in your important work. Importantly, the letter also details the various ways in which we are attempting to rectify the problems, both now and for the future. And again, I will say a little more about those matters shortly. So, as you have observed in your opening remarks, the inquiry has already made very considerable progress, both in terms of upscaling its own operation and in terms of gathering material and calling evidence. There is much that the MOD has done to support the inquiry in its work so far. We've set out some details of this support in our letter. In summary, the MOD has provided funding for the inquiry team that so far stands at £6 million. The MOD has established 3 entirely new internal units to respond to and engage with the inquiry. Those units are separate from and additional to the RMP core participant team, which functions independently from the MOD core participant team, but which the MOD has also been responsible for setting up and resourcing. The MOD core participant team, i.e. the 3 units to which I've referred, currently has more than 80 people working on and for it, comprising military personnel, civil servants, solicitors and counsel. In the next few weeks, that number will rise to more than 90, with the addition of 10 further paralegals. The budget of the MOD team is currently projected to be over £15 million, a figure that is likely to rise. So, may I step to one side for a moment and deal briefly with the submissions that you've heard from Mr. Hermer about the disclosure problems in the JR claim. And so it is of course true that the issues that have led to this hearing are an unfortunate echo of similar problems that occurred before the inquiry was set up during the litigation. Of course, I'll have more to say about those problems in a moment, but I hope it's apparent from what I have just said about the resources being dedicated to supporting you, that the resources that are available to provide that support, and in particular to deal with documentary evidence and so on, bear no comparison to resources that would be available to deal with the previous litigation, or for that matter, any other litigation. This matter is being dealt with in a very special way, and as I will come to say, we hope that this will be the first and last time we have to address you on matters such as this. So much of the upscaling of the MOD's capacity has taken place since and as a result of a meeting between you and the Ministry of Defence's Permanent Undersecretary in October last year. It's also right to say that we would have wished to increase our resources more and more quickly than we have in fact achieved. In our letter, we provided details of the challenges that we have faced in that respect. By way of example only, the need for incoming staff either to hold security clearance or to undergo the clearance process, which necessarily involves a delay, and also the general scarcity of junior legal resource, especially individuals with security clearance, due to competing demand from other large-scale litigation that is ongoing and public inquiries, such as the COVID inquiry and the undercover police inquiry. So nonetheless, the teams, the personnel that we have managed to put in place have enabled us to respond to a large number of requests for documents and witness statements made by the inquiry to the Ministry of Defence. It's right, of course, that in respect of one of the inquiry's requests for documents, indeed one of your central requests, the MOD has not managed even to come close to complying. That is why we're here today, and I will come back to that point. It's also true to say that there have been delays, albeit delays that have not threatened your timetable, in complying with other requests, and we have given some explanation for those delays in the letter. But, sir, none of that should obscure the fact that the MOD team has already, in the lifetime of the inquiry, disclosed thousands of documents, provided many witness statements, including some lengthy statements from very senior witnesses, and done much else besides to support the inquiry, including compiling detailed schedules of DDOs, which, as you have said, were of use to the inquiry in the early stages of its work, and indeed organising the DDO demonstration that is mentioned in our letter and to which you have referred. So it's with that context in mind that I now turn to the difficulties that have arisen with the Phase 3A disclosure exercise, which have prompted you to convene this hearing today. In summary, this disclosure exercise requires the MOD to search for, schedule and disclose all relevant documents that it holds relating to 10 deliberate detention operations that took place in Afghanistan within the period under examination by the inquiry. It's intended to be a comprehensive exercise. One term used in discussion is that the MOD must empty its cupboards of documents relating to these operations. Documents falling within this category are held in different places and on different systems within the MOD. Many are classified, some at the highest levels of classification. The Rule 9 request for this category of documents was sent by the inquiry to the MOD on the 5th of February this year, with a request that all documents be provided by the 11th of March. Once the MOD began scoping this request, it was apparent that the task was a huge one and that completing it would take very much longer than the period of 5 weeks that the inquiry had allowed. The inquiry is aware of the difficulties we have faced from discussions, from our updates, and also from yesterday's letter. But in summary, the total number of documents that will need to be reviewed for relevance is likely to be in the region of 100,000 documents. And it is to be noted that that is a figure which has been reduced following the refinement of search terms in discussion with your team. As already mentioned, the great majority of the documents are classified, and the task of reviewing and processing them is made much more laborious and slower by the fact that the MOD does not have e-disclosure software on its classified systems, albeit that efforts to remedy that problem are underway and detailed in our letter. Most seriously, and in the light of these other problems, the MOD simply does not have enough staff, at present security-cleared paralegals, to get through the work of reviewing and scheduling the documents at anything like the pace needed to comply with the inquiry's proposed timings. So the inquiry has understandably asked why this problem was not envisaged and catered for in advance. With hindsight, I can assure you that we all wish it had been, and you have the MOD's apologies that it was not. By way of explanation, what I can say is, first, the sheer scale of the Phase 3 exercise, that is, that it would require a review of as many as 100,000 documents, was simply not understood until it was too late. Although the MOD's team, and of particular relevance here, the level of paralegal support, had grown in late 2023 and early 2024, it had not grown as much as had been planned or hoped due to difficulties in procurement and recruitment that are detailed in the letter. Once the scale of the problem was understood, the same problems have prevented us from rapidly upscaling the paralegal support. In short, there simply are not large pools of security-cleared paralegals or junior counsel available and waiting to be recruited, and government procurement rules also delay the process of contracting with panel firms. As yesterday's letter explains, sir, the MOD has put in train various initiatives towards solving this problem, i.e. increasing the resource available for reviewing and scheduling documents. Some of these processes have been in train for several weeks now. These matters are set out in some detail in yesterday's letter, and in particular in the annex to that letter. I don't intend to repeat all that is there in detail now, sir. But in summary, first of all, various different attempts are being made to recruit and deploy further personnel into the MOD's Afghanistan Inquiry Response Unit. In other words, for the purposes of the annex, that is what is described as methods 1, 2 and 3. So the intention is to supplement the staff in the unit, in particular staff to conduct disclosure review, through 3 processes: civil service recruitment, external contracting of paralegals and solicitors, and the recruitment of military personnel. So the first 2 of those processes are already in train. The challenge is to recruit staff with security clearance, and numbers are limited. And there is an element of process that inevitably delays those processes for reasons explained in Annex A. So the third process, the recruitment of military personnel, is, I think, the process that Mr. Hermer was referring to a moment ago when he talked of individuals within the chain of command being involved in the disclosure exercise. So, in principle, this means of undertaking the process is attractive in that it involves relatively large amounts of resource, all security cleared, who can be recruited within a relatively short time frame. So as we stated in the letter, and possibly prefiguring the concerns that Mr. Hermer has touched on this morning, this approach had not been previously considered because the individuals involved would not have any legal training and might also be thought, in particular given the issues involved in this inquiry, to lack sufficient independence. However, sir, faced with the difficulties and what we know is your desire for expedition, we have been trying, to put it bluntly, to think outside the box. It is at least possible, we think, that sufficient mitigations can be put in place to address these concerns, involving, for example, the work of military personnel being checked by MOD lawyers to make this approach viable. But can I emphasise, sir, that this is not a step that we would take without full discussions with your team. It is a possibility that has only arisen in the last few days. I have already had brief informal discussions about it. But one of the points I made clear, and indeed the reason I had those discussions, was that I wished it to be understood that this was not an approach that we would take without full discussion with the inquiry, a proper understanding of what was involved, and ultimately, sir, your approval. So those are the attempts to supplement the staff within the unit. A second approach, which is detailed in the annex, it is a freestanding contract with an external solicitors firm to, as it were, bolt on resource to the unit. The budget for that project is currently set at £5 million. That approach involves no fixed number of solicitors or paralegals. Indeed, one of the attractions of it is that we anticipate there will be an ability to expand resource according to need. That is attractive in particular because we know that there will be many other tasks to undertake alongside the Phase 3A work over the coming weeks and months. So this process of contracting with a solicitor's firm is now well advanced. We hope that the firm can be recruited on an expedited process via a direct award within the next few weeks, and that at least some of their staff will be able to start almost immediately. So as I've said, the finer detail of those work strands is set out in our letter. But if I may, I will just make 3 more general points relating to them. First of all, and to emphasise, that these different work strands are not alternatives. The Ministry of Defence is pursuing them all in parallel. Second, although the immediate priority is to obtain resource necessary to complete the 3A disclosure exercise, we also have well in mind that we must not allow a similar situation to occur again. We are, of course, aware that there is much more that the inquiry will ask of us, and our intention is that these further resources will enable us to respond to further requests speedily. Third, I have mentioned, and indeed the letter mentions, constraints in terms of public procurement rules and so on. So whilst some rules necessarily have to be observed when large sums of public money are being spent, the Permanent Undersecretary of the MOD has made it clear and has, in the last few days, repeated his call that wherever possible, processes should be expedited in order to support the inquiry. So the Phase 3A disclosure exercise is now well underway. Several thousands of the documents have already been reviewed and many documents already provided to the inquiry. But the bulk of the work still lies ahead, and you will of course want to know what everything that is said in the letter and what I have said today mean in terms of timing. In particular, our current estimate of when we're likely to complete the process of reviewing the Phase 3A documents and providing those that are relevant to the inquiry. This question has been carefully considered. It's difficult because, notwithstanding the direction from the top of the building that all possible resources should be devoted to completing the 3A disclosure exercise as swiftly as possible, there remain many variables and contingencies. Some of the uncertainty relates to work strands that are still at an early stage. Given what has happened so far, we are very cautious about over-promising. What I can say, sir, is that with a fair wind, the inquiry will start to receive an increasing flow of 3A documents over the coming weeks and months, and we very much hope to provide the vast majority of the 3A documents to the inquiry by the end of August. As you know, sir, we are already providing the inquiry with detailed written updates on the process of the 3A disclosure exercise. We will, of course, continue to do so, and if our expectations of the end date change in any way, we will alert the inquiry immediately. So I'm grateful that those are all the submissions I wish to make.
Thank you, Mr. O'Connor. What you've said very clearly and helpfully is welcome. Cost savings and inquiries, as we know, can be very significant where inquiries move at pace. So there is a very good business case for investing now in order to get this inquiry through. Just a few points. Firstly, you mentioned 10 DDOs are the subject of Phase 3. Those, as you know, and as I explained, are simply sample DDOs for the purposes of the Phase 3 exercise. I'm about to say, and you mentioned hindsight, it would have been wise to have conducted the test run in October, I think, when it was first mooted, as indeed was done for Phase 1 and 2, and that is an important lesson for everyone, which would have revealed the scale of the task. You mentioned the use of military personnel, and that is an option which makes some good sense in relation to many of the administrative tasks that would be involved in this exercise, and no doubt guardrails can be put around their particular role. But I'm glad to hear that all options are open and that everybody is gathering together to make this exercise one as speedy as it now can be. I'd like you to liaise very closely with my inquiry team, and perhaps in a couple of weeks get back in touch with them and keep them carefully informed as to progress in relation to recruitment and the other steps that are being taken. Good. Mr. Glasgow, is there anything I need to further I need to deal with?
No, nothing. Thank you very much indeed, sir.
Good. Well, I'm grateful for everybody's attendance. We will now adjourn, please, and further steps will be outlined by the inquiry team. Thank you very much indeed.